the CEO's estate was frozen until her signature solved the mystery, her signature, and the first thing everyone noticed in courtroom 9 that morning was not the judge, not the lawyers, but a single sealed envelope sitting on the wooden evidence table with a black corporate stamp that had been marked Restricted Estate Authorization in faded ink. Nobody touched it at first. It looked too ordinary to matter, like the kind of administrative file that gets buried in legal storage rooms and forgotten for years, until a court clerk quietly placed it into the record and said the words that changed the entire room: "This document is part of the original CEO succession file." At that moment, Emily Carter sat in the second row of the courtroom, dressed in a simple navy blouse and neutral slacks, her posture calm but unreadable, the kind of calm that makes people assume she has nothing at stake. Across from her, the board's legal team exchanged confident glances, already preparing arguments about why she had no authority, no ownership claim, and no executive standing in the frozen estate of the late CEO, Richard Halston's business successor structure. Beside her sat Walter Gaines, the quiet white billionaire mentor everyone underestimated because he never raised his voice, never performed confidence, and never needed to. He was the kind of man who didn't argue about money because he already understood where it was legally anchored. The estate freeze had been triggered 3 weeks earlier when conflicting ownership claims surfaced over Halston Enterprises, a multi-billion-dollar logistics and real estate portfolio structured through layered trusts, holding companies, and private authorization agreements. Bank accounts were locked. Payroll systems were paused. Vendor payments stopped. Entire divisions of the company were now waiting for a single legal determination of control. And yet, in the middle of all that financial paralysis, nobody could agree on one thing: whose signature actually authorized continuity after the CEO's death. That was where Emily Carter entered the narrative, though the board insisted she was nothing more than an administrative assistant who had access to files, not authority over them. But what they ignored was what she actually controlled behind the scenes for years: compliance records, internal contract tracking, bank verification logs, and executive authorization archives that most board members never even read. In a corporate system built on signatures, Emily had spent years organizing the signatures themselves. And Walter knew something the board didn't: wealth does not collapse when people argue, it collapses when signatures cannot be verified. The CEO, Richard Halston, had built his empire with extreme precision. Every acquisition, every loan structure, every shareholder agreement had layers of legal protection designed to survive death, lawsuits, and internal betrayal. He was not a man who trusted titles. He trusted documents. Deeds over promises. Contracts over conversations. Bank records over reputations. And somewhere inside that sealed envelope on the evidence table was the final layer of that system, the one document nobody in the boardroom wanted to acknowledge might exist. The tension in the courtroom began to rise not because anyone spoke louder, but because silence itself became heavier. The board's lead attorney leaned forward and stated clearly for the record that Emily Carter's name did not appear on any official ownership registry, any executive voting agreement, or any succession clause submitted during probate review. In their version of reality, that was the end of her involvement. But Walter simply looked at the envelope again, calm and unchanged, as if the argument had already been answered long before the hearing began. Because he had seen the internal ledger history attached to it, the bank authorization trail that showed continuous financial oversight even after the CEO's death, and the contract clause referencing a designated operational continuity signer whose identity had never been publicly confirmed. Emily did not react. She never tried to prove herself in the way people expected. She did not interrupt, she did not argue, she did not perform urgency. Instead, she remained still, as if waiting for something already written to be read aloud at the correct time. And that is what made the board uneasy. Because in corporate disputes, people who are loud usually want control. But people who are quiet often already have documentation. The CEO's estate was frozen not because of missing money, but because of missing clarity, whose signature legally kept the system alive when the founder was no longer there to sign anything himself. And as the clerk prepared to open the sealed envelope, nobody in the room realized yet that this single file did not just contain evidence, it contained the answer to a question the entire company had been avoiding since the moment Richard Halston died. After the court adjourned for the day, the frozen estate case did not go back to silence. It spilled into the real world of bank lobbies, suburban kitchens, and glass-walled boardrooms where money decisions actually live or die. In a quiet suburban neighborhood outside Chicago, Emily Carter sat at a small wooden table surrounded by the kind of documents most people ignore until it's too late: mortgage statements, insurance renewals, utility bills, and printed bank account histories from multiple business entities tied to Halston Enterprises. Nothing about the room looked powerful. No luxury. No assistants. No boardroom lighting. Just paper, a laptop, and a calm young woman in her early 30s carefully cross-checking numbers line by line with the patience of someone who understood that ownership is never emotional, it is procedural. Emily never looked like someone who belonged in corporate litigation. That was the mistake everyone made. They saw her simple clothing, her quiet tone, her lack of public presence, and assumed she had no financial literacy worth respecting. But Emily had spent years inside the administrative backbone of Richard Halston's private operations, reviewing vendor contracts, reconciling internal cash flow reports, and tracking authorization signatures across multiple subsidiaries. While executives debated strategy in glass offices, she was the one verifying whether the numbers in those strategies actually matched the bank records. Meanwhile, across town, the Halston legal team continued presenting her as an irrelevant figure in the estate structure, someone with access to files, not authority over them. But what they never fully understood was that access to records is exactly how you learn where control actually lives. Control is not in titles. It is in signatures, timestamps, and approved transaction flows that most executives assume someone else is handling. That morning, Emily reviewed a series of payment logs showing continued financial activity on accounts tied to the CEO's private reserve structure even after his death. The transactions were small but consistent: property tax payments, insurance continuity fees, vendor stabilization transfers. Someone had been keeping key assets operational while the board assumed everything was frozen and inactive. That contradiction did not confuse her. It confirmed something she had quietly suspected for months: that the system was not broken, it was just incomplete in the way it was being interpreted publicly. Richard Halston had designed his financial world like a layered structure. Public-facing companies. Private holding entities. And underneath that, operational continuity protocols that only activated under specific legal conditions. Emily didn't discover those systems by accident. She learned them the same way Richard taught everything: by repetition, observation, and responsibility without recognition. There were no speeches. No formal lessons. Just years of being present while real financial decisions were made in silence. Across those years, she also learned something else: people in power often mistake visibility for control. The board believed that because they held meetings in expensive rooms and signed documents under corporate titles, they were the only ones with authority. But authority in structured finance does not always sit in the front of the room. Sometimes it sits behind the filings, reviewing what others assume is already approved. That is where Emily lived professionally, inside the paperwork no one else wanted to read carefully. Meanwhile, Walter Gaines remained the only person who never underestimated her role. He didn't treat her like a victim or a mystery. He treated her like someone who understood systems. In his decades working with estate structures, he had seen the same mistake repeat itself: people assume the loudest voice in the room controls the money, when in reality, the money follows the documents that were prepared long before anyone started arguing. That afternoon, Walter visited a small law office downtown, reviewing archived authorization files connected to Halston Enterprises. He didn't rush. He didn't speculate. He just read. Because in his experience, financial truth does not appear through confrontation, it appears through consistency in paperwork. And somewhere inside those archives was the sealed document from the courtroom, the one still waiting to be fully opened, the one the board had already begun quietly trying to discredit without even seeing its full contents. Back at her table, Emily paused for a moment, staring at a printed ledger showing a line of authorization entries tied to a single unknown signature code that had never been publicly assigned to any executive role. It didn't match the CEO. It didn't match the board. It didn't match any listed administrator. But it matched something far more important, the internal continuity designation referenced in the frozen estate filing. She didn't speak. She didn't react. She simply placed the document back into the folder, as if acknowledging that the final misunderstanding everyone was defending so aggressively was about to collapse under its own paperwork. And in that silence, one question remained unanswered. If the board's version of control was correct, then why did the financial system continue functioning under a signature no one was willing to officially recognize? In every financial collapse, there is a moment before the truth is revealed where people are still clinging to the wrong assumptions, and in this case, it all comes down to the beliefs that shaped how everyone in the room interpreted Emily Carter, Richard Halston's estate, and the frozen structure of Halston Enterprises. The first false belief was simple but powerful. They assumed that someone who dresses modestly, speaks softly, and avoids attention must not have financial relevance. In the board's eyes, Emily was just another administrative presence, useful for paperwork, but irrelevant to ownership. What they failed to understand is that in modern corporate systems, visibility has nothing to do with authority. Ownership is not worn. It is recorded. It is signed. It is verified through bank trails, contract logs, and authorization chains that most people never bother to read. The second false belief was even more damaging. They assumed silence meant weakness. Emily did not argue in meetings. She did not interrupt legal discussions. She did not challenge executives in public. So they assumed she had nothing to contribute. But silence in financial environments is not absence, it is observation. The people who truly understand systems often speak last, because they are waiting for documentation to confirm what others are only guessing. Meanwhile, in the suburban offices and legal rooms surrounding this case, Walter Gaines continued reviewing filings without emotion, because he understood a truth most executives forget: being loud in a boardroom does not make you correct, and confidence without records is just performance. Another misconception came from how people confused living conditions with ownership. Just because someone lives in a house does not mean they own it. Just because a company operates under a CEO's name does not mean that person controls the underlying structure. Mortgage statements, deed filings, trust agreements, and tax records are what define ownership, not appearances or assumptions. Yet in this case, many of the board members built their entire argument on perception rather than documentation. They assumed that because Richard Halston had been the visible CEO, all authority naturally flowed through them after his death. But they ignored the deeper architecture he had built beneath the surface, where actual control was tied to structured legal design rather than executive titles. The fourth false belief was about family and succession. They assumed that proximity to power, being on the board, being related to executives, being part of the company culture, meant entitlement to inheritance and control. But estate law does not recognize emotional proximity. It recognizes legal designation. Wills, amendments, trust clauses, and signed authorization files determine who has authority, not assumptions about loyalty or involvement. In the same way, many people assumed that the CEO title itself meant he was the sole creator of the company's structure. But in reality, businesses of this scale are rarely built by one person alone. They are built through layered contributions, hidden operational systems, and individuals like Emily who maintain the integrity of financial records long after the public narrative has moved on. Then there was the confusion between cash flow and ego. The board believed that controlling meetings, presenting projections, and managing investor confidence meant they controlled the company's financial reality. But cash flow does not respond to confidence. It responds to accounts, approvals, and signed authorization. A spreadsheet presentation does not move money. A verified instruction does. Another dangerous misunderstanding came from equating presentations with creation. Just because someone delivers a business strategy does not mean they authored it. Original work is embedded in version history, email trails, internal drafts, and approval timestamps, none of which can be replaced by confident storytelling in a boardroom. And perhaps the most critical misunderstanding of all, they believed a signature was simply a formality, a confirmation of agreement. But in structured finance and estate law, a signature is not symbolic. It is authority. It is control. It is the exact point where responsibility becomes legally enforceable. Yet even that belief was incomplete, because what the board failed to consider was whether the signature they were relying on actually matched the legal continuity structure Richard Halston had embedded into his estate plan. At one point during the internal review, Emily sat alone with those records in front of her, asking herself a question that anyone watching might also consider in their own life: how many things look stable only because we never actually read the documents behind them? Because that is where this entire case begins to shift. Not in emotion. Not in public perception. But in the gap between what people assume is true and what the legal record actually confirms. And somewhere inside that sealed authorization file from the courtroom, the mechanism that holds the entire estate freeze in place is beginning to reveal itself, not through argument, but through the structure of law that was designed long before anyone in the boardroom realized they were no longer in control. To understand why Halston Enterprises is frozen in the first place, you don't need advanced finance knowledge, you just need to understand how American legal and financial structure actually works when ownership, signatures, and authority collide in probate court. The first rule is simple: the will only controls distribution when it is legally valid, properly executed, and recognized by the court. That means signatures, witnesses, timestamps, and jurisdictional compliance all matter more than intent or family assumptions. In this case, the sealed authorization file sitting in the courtroom is not just symbolic, it may contain the validation layer that determines whether any version of the estate plan is enforceable at all. Next comes the deed. A deed is not emotion. It is not history. It is not relationship. A deed is ownership recorded in legal form. When Emily Carter reviews property documents tied to Halston assets, she is not looking at stories, she is looking at recorded authority. Who is listed? Who transferred rights? Who retained control under specific clauses? That is where ownership actually lives in the United States system, not in boardroom discussions or verbal agreements. Then there is the mistake people make about mortgages. Many assume that paying for something over time equals ownership, but mortgage payments only prove financial responsibility, not legal title. A person can carry the burden of payments for years and still not be the legal owner if the deed says otherwise. That is why Emily's quiet review of mortgage histories tied to Halston Properties matters so much. It is not about who paid, it is about whose name controls the title once the structure is legally tested. Bank records become the next layer of truth. In American corporate estates, bank records are often more honest than people. They show who actually carried operational burden when systems were under stress, who approved continuity payments, and who maintained asset stability when others assumed everything had already stopped. That is why Walter Gaines spends so much time reviewing transaction histories instead of arguments. Money movement leaves a trail that opinions cannot erase. But even beyond money flow, contracts are where real power sits. A contract is not just paper, it is enforceable authority. It defines what happens when people disagree, when someone dies, or when control is disputed. In Emily's situation, reviewing contract clauses tied to Halston Enterprises is not theoretical. It is survival-level financial literacy. One clause can determine whether she has no standing or full operational authority under emergency succession structure. And sometimes, the smallest piece of evidence carries the most weight. An old email chain can prove authorship of intent, decision-making authority, or original creation of a business structure. That is why Walter insists on reviewing archived communications instead of relying on memory or board testimony. In corporate law, whoever can prove origin often wins over whoever can claim narrative. Even business plans follow the same rule: they have an origin point, a draft history, and a trail of revisions that reveal who actually built the structure and who only presented it later. Meanwhile, boardroom titles create another illusion. A CEO title or executive role does not erase receipts, approvals, or financial records. It only defines public-facing authority, not necessarily legal control of underlying assets. That distinction is exactly where most corporate disputes collapse. Payroll data adds another layer of truth. It reveals priorities: who was funded, who was maintained, and which departments were protected during instability. Payroll is not just accounting, it is a map of operational trust inside a company. And then there is fine print, the quietest but most dangerous part of any system. Fine print can protect ownership, restrict authority, or transfer control without anyone noticing until it is enforced. That is why Emily, in a small law office earlier that day, did something simple but critical. She opened the full probate file instead of only reading summaries provided by opposing counsel. She checked the deed history line by line. She compared signature timestamps across multiple documents. She pulled bank records tied to continuity accounts. She reviewed archived email chains tied to authorization updates. And she stopped when she reached a clause referencing emergency continuity signature authority under designated non-board operator status. That clause was not widely discussed in court yet. In fact, most of the board seemed unaware it existed in full legal form. Walter didn't react when he saw it. He simply closed the file slowly, as if confirming something he already suspected. Because in structured estate law, hidden authority is never about surprise, it is about documentation waiting for the correct moment of recognition. And as the sealed envelope from the courtroom is finally prepared for full disclosure, the next question is no longer what the board believes, but what the signature inside it legally activates once it is fully opened. Inside the restricted records room of the downtown Chicago probate court, the sealed envelope from Halston Enterprises was finally placed on the table in front of Emily Carter, but still not opened, just repositioned under stricter evidentiary protocol, as if the system itself was preparing for a moment it had been designed to delay. Around her, lawyers adjusted their posture. Board representatives leaned forward. Even the clerk paused, waiting for procedural confirmation. And yet Emily did not move like someone waiting for permission. She moved like someone who already knew what was inside, not emotionally, but structurally. That is what made the room uneasy. On the table beside the envelope was the full legal folder now assembled from multiple sources, the forgotten will, the notarized amendment pages, the property deed chain, and a sealed authorization letter containing an old executive signature code tied directly to Halston Enterprises' continuity structure. None of it looked dramatic. In fact, it looked almost boring, standard legal paper, stamped and filed, the kind of documentation most people would overlook if they didn't understand that ownership in America is rarely decided by appearance. Emily sat calmly in a simple chair, hands folded, her expression steady in a way that made people assume she was disconnected from the stakes. But Walter Gaines, sitting slightly behind her, had already recognized something the others hadn't. She wasn't unprepared. She was already finished preparing long before the hearing began. The forgotten will inside the folder was not new information to her. Neither was the deed amendment listing operational authority tied to specific commercial assets. Neither were the bank continuity records showing that certain payments had been maintained under an authorization structure no one on the board had publicly acknowledged. Emily had seen these pieces before, and not in fragments, but in full context. Because Richard Halston had never trusted power to visibility. He trusted it to documentation discipline. Across the room, the opposing legal team continued to argue from a position of hierarchy rather than structure. They emphasized titles, board authority, executive control, and corporate voting rights. But every one of those arguments rested on a single assumption, that leadership titles automatically matched legal ownership. And that assumption was starting to fail under the weight of the evidence sitting quietly on the table. The sealed letter with the old signature was now partially visible through the folder edge. It was not flashy. It did not look powerful. But it carried something far more dangerous in a courtroom than emotion, continuity or authority. A signature that, if validated under probate conditions, could override board interpretation entirely. Walter did not interrupt the proceedings. He simply observed the way Emily looked at the documents, not with surprise, not with relief, but with recognition. Like someone confirming a system she had already studied in motion for years. That was the moment the board began to misread her again. They saw her calmness and assumed she lacked urgency. They saw her simple clothing and assumed she lacked financial weight. They saw her lack of public title and assumed she lacked legal relevance. But what they were actually witnessing was someone who understood a principle most people in corporate conflict never grasp. People who understand money do not win by being loud, they win by keeping records, reading terms carefully, and letting proof arrive exactly when the system is forced to acknowledge it. Emily had not built her position through confrontation. She had built it through exposure to documents most executives never bothered to verify. Mortgage continuity logs, payroll alignment sheets, internal approval emails, and compliance trails that connected operational survival back to a single authorization structure. Meanwhile, Walter Gaines recognized something else. She was not reacting because she was not discovering anything new in real time. She was waiting for everyone else to catch up to what had already been legally recorded. That difference, between discovery and confirmation, was where most financial disputes are decided. The board, however, remained convinced that she was still irrelevant. In their view, influence came from visibility, negotiation, and rank. Not from quiet familiarity with documentation systems. Not from understanding how bank records interact with estate clauses. Not from knowing how a single signature line in a sealed file can redefine authority under probate law. As the clerk prepared to escalate the envelope to final opening authorization, Emily finally shifted her gaze, not toward the document, but toward the opposing side of the room, where pressure was beginning to build in small, visible ways. Attorneys whispering. Executives checking notes. Investors watching the delay with increasing discomfort. Because they all understood, even if they wouldn't say it yet, that frozen estates do not unfreeze through argument. They unfreeze through verification. And verification always begins with documents no one wanted to fully open until the pressure becomes unavoidable. The sealed folder on the table was no longer just evidence. It was becoming a trigger point for everything the board had tried to keep stable through assumption rather than confirmation. And as the judge signaled for the final opening procedure to begin, one thing remained unclear to everyone in the room except perhaps Emily herself. When the envelope was finally opened in full, would it confirm the board's version of control, or reveal that the entire structure had already been operating under a signature they had never truly understood? As the sealed envelope finally rested on the probate court table under full evidentiary review, the atmosphere in courtroom 9 shifted from controlled procedure to controlled pressure. Nothing was loud, but everything was tightening. Lawyers on the opposing side began to adjust their strategy in real time, not because new information had arrived yet, but because the possibility of what was inside that envelope was becoming more legally dangerous with every passing second. Emily Carter remained still, seated with quiet discipline, her expression unchanged. Not defensive. Not emotional. Just present, as if she had already lived through every argument they were about to make. And that, more than anything else, unsettled the room. The opposing board representatives were the first to escalate. They did not argue the documents yet. Instead, they attacked her presence. One of them leaned forward and addressed the court in a controlled but dismissive tone, stating that Emily Carter had no recognized executive title within Halston Enterprises, no voting rights, no formal equity position recorded in the public shareholder registry, and therefore no legitimate standing to influence estate interpretation. It was a familiar strategy in corporate disputes: reduce a person to what is visible on paper today while ignoring what was structured in documents yesterday. Another attorney followed quickly, attempting to frame her involvement as administrative at best and opportunistic at worst, suggesting that proximity to files did not equal authority over assets. The implication was clear without needing to be stated directly: she was being positioned as replaceable, irrelevant, and legally inconsequential. Across the aisle, investors and board affiliates exchanged subtle looks of agreement, not because they had seen the evidence, but because they believed hierarchy should determine truth before documentation is even reviewed. That is where pressure begins to distort financial judgment. Because in high-value estate and corporate disputes, pressure does not just test truth, it tests patience. And patience is often where people lose ownership without realizing it. Walter Gaines observed quietly from his seat, not reacting to the verbal framing being built around Emily. He had seen this pattern before in estate litigation and corporate succession cases, when documentation is strong but not yet fully revealed, opposing parties often attempt to force early settlement language, emotional concessions, or procedural withdrawal from less experienced individuals. Not because they are correct, but because pressure creates exhaustion. And exhaustion creates bad decisions. The court clerk began organizing the sealed authorization file for formal opening, but the judge had not yet authorized disclosure of its full contents. That gap, between awareness and confirmation, is where most legal outcomes are shaped. Meanwhile, the opposing legal team intensified their narrative. They suggested that continued challenge to the estate freeze was destabilizing corporate operations. They referenced investor confidence, employee uncertainty, and market exposure risks. These were not legal arguments about ownership. They were emotional pressure points designed to push faster resolution. Because in financial disputes, urgency is often weaponized. If you can make someone feel like delay is damage, you can sometimes make them sign away rights just to restore peace. Emily understood that dynamic more clearly than anyone speaking against her. She had seen it before in smaller systems: contracts rushed under pressure, approvals granted to avoid conflict, signatures given not because they were correct, but because they felt necessary in the moment. That is how ownership is quietly lost, not through theft, but through exhaustion disguised as compromise. One of the board members finally directed a statement toward her directly, implying that if she truly cared about stability, she would step back and allow proper executives to resolve the estate freeze without external interference. It was framed politely, but the meaning was clear: withdraw now, avoid conflict, accept status limits, and let the system proceed without her involvement. The kind of suggestion that sounds reasonable in a tense room but often results in permanent legal disadvantage once accepted. Emily did not respond immediately. Not because she lacked an answer, but because she understood something fundamental about structured finance and probate law: speaking too early in a system built on documentation is often less powerful than waiting for the record to speak first. Walter, noticing the escalation, finally spoke in a calm voice, not to argue, but to anchor the record. He reminded the court that the sealed authorization file was not being introduced for interpretation, but for verification. That distinction mattered. Interpretation is opinion. Verification is law. The judge acknowledged the point without emotion, instructing that the court would proceed only once the full file was opened under proper procedural authority. The pressure in the room did not decrease. It shifted. Now it was no longer about whether Emily would respond, but about whether the documents would confirm or collapse the narrative the board had built so confidently. And that is where the most important financial truth of the entire case became unavoidable: people who truly understand money do not respond to pressure by rushing decisions. They do the opposite. They slow down, they wait for verification, and they allow structure, not emotion, to decide outcome. Because once the sealed envelope is opened, there is no longer a way to rely on assumptions. Only records. Only signatures. Only what the system can legally sustain when everything else has been stripped away. And as the clerk placed a hand on the sealed authorization file, preparing to finally open what had been protecting the estate's true continuity structure all along, the question hanging over the courtroom was no longer about Emily Carter's role, but about what kind of authority had actually been operating the entire company in silence while everyone else believed it was frozen. When the sealed authorization file finally opened in Courtroom 9, there was no dramatic sound, no interruption, no reaction from the gallery at first, only the quiet friction of paper being separated by a court clerk who had opened thousands of legal documents in her career, but none that felt quite like this. Inside was not just one document, but a structured chain of authorization records tied directly to Halston Enterprises' continuity system. The first page confirmed the existence of a designated emergency operational signature authority embedded within the CEO's estate structure. The second page listed the legal activation conditions. The third page contained the signature code itself, old, consistent, and verified through multiple bank authentication layers. And then the courtroom went still. Not because anyone told them to be quiet, but because the system itself had shifted from argument to confirmation. Emily Carter did not react. She did not lean forward. She did not claim victory in any visible way. She simply looked at the documents as they were read aloud, as if recognizing something she had already lived through in practice, even if others were only now seeing it on paper. Walter Gaines, however, finally exhaled slightly, not in relief, but in recognition. Because everything he had suspected about the estate structure was now no longer theory. It was record. The clerk continued reading. The will was confirmed as valid under probate standards, but more importantly, it referenced a layered operational instruction that most board members had either ignored or misunderstood. In the absence of the CEO, continuity authority transferred not to a single executive title, but to a designated internal operator responsible for maintaining financial stability across debt obligations, payroll continuity, and asset protection systems. That operator, according to the document, had been assigned years earlier. The name listed on the authorization line was not a board member. It was not a successor CEO. It was not a family heir. It was Emily Carter. The room did not react loudly. It did not need to. The silence that followed was heavier than any objection. Because in that moment, multiple assumptions collapsed at once. The board's legal team stopped speaking mid-sentence. Investors who had been leaning forward now leaned back slightly, recalibrating what they believed they understood about the estate freeze. Even the judge paused, eyes moving from the document to Emily, then back again, as if confirming that what had just been read matched what was legally binding. The second layer of the file revealed something even more critical: financial responsibility continuity. Bank records attached to the authorization file showed that during the period immediately following the CEO's death, mortgage obligations on key commercial properties had not lapsed. Tax payments remained current. Payroll for essential operational divisions had been maintained. Vendor contracts had not defaulted. And every single one of those financial stabilizations traced back to the same authorization signature chain now validated in court. The implication was not emotional. It was structural. While the board believed the estate was frozen, parts of it had been quietly stabilized under a pre-existing legal framework they had never fully activated or understood. The court clerk continued reading, now confirming deed alignment records that tied specific commercial assets directly to the same continuity structure. Ownership was not being guessed. It was being confirmed through layered documentation, deeds, bank trails, contract clauses, and signed internal authorizations that all converged on a single point of legal authority. Emily Carter was not just present in the system. She had been embedded in its operational survival layer. Across the aisle, one of the senior board attorneys attempted to speak, but the judge raised a hand slightly, not to silence him emotionally, but procedurally. Because once verified documentation reaches this level of clarity, argument becomes secondary to enforcement. Walter finally spoke in a calm, measured tone, not directed at anyone in particular, but enough for the record to carry: money gets loud when people lie. Proof gets quiet when it is true. No one responded. Because no response was required. The documents had already spoken in the only language that mattered in that room. The CEO's estate was not frozen due to lack of ownership. It was frozen due to misunderstanding of structure. And that misunderstanding had now been corrected through verified legal proof. The judge instructed the clerk to formally note the continuity authority recognition into the probate record and begin procedural steps for partial unfreezing of designated operational assets under confirmed authorization structure. This did not resolve every dispute, but it resolved the most critical question: who had legal authority to keep the system functioning when the CEO was no longer present? As the file was closed, the courtroom did not erupt into celebration or conflict. It simply recalibrated. Attorneys stopped speaking. Investors stopped speculating. Even the board members who had confidently dismissed Emily moments earlier now sat in silence, re-evaluating every assumption that had led them here. And as the hearing moved toward its next procedural phase, one thing became clear to everyone in the room: the legal outcome of the estate would no longer be decided by perception, titles, or pressure, but by the consequences of a signature that had already been operating in silence long before anyone in the boardroom realized they were no longer the ones in control. The legal consequences did not arrive as a single dramatic moment; they unfolded like a system correcting itself after years of misinterpretation. Within hours of the probate court's verified recognition of Emily Carter's continuity authority, Halston Enterprises was no longer treated as a fully frozen estate. Instead, it entered a structured partial release phase, supervised jointly by the court, the estate executor, and corporate compliance officers. The first official action came from the court-appointed estate lawyer, who confirmed on record that the sealed authorization file was not only valid, but fully aligned with the original CEO succession framework. That confirmation changed everything downstream. The judge reviewed the clause again personally, this time not as a disputed point, but as an enforceable instruction embedded in the estate design itself. Under that clause, specific operational assets, those tied to payroll stability, debt servicing, and essential vendor contracts, were legally authorized to continue under designated continuity control. That meant the freeze was no longer absolute. It was conditional. And conditions require administrators, not arguments. The deed records tied to Halston commercial properties were formally cross-verified with county filings. The mortgage histories were reviewed line by line against bank compliance logs. Tax receipts confirmed uninterrupted payment continuity during the disputed period, eliminating any claim of financial neglect or abandonment. The court did not interpret these facts emotionally. It processed them structurally. And once verified, the legal system adjusted accordingly. The estate distribution itself was not finalized yet, but it was legally corrected in direction. What had been treated as an undefined conflict of authority was now a documented hierarchy of responsibility. That meant certain board decisions were temporarily invalidated, not as punishment, but as procedural correction. The corporate board, which had previously assumed operational authority, was now required to submit all future actions involving frozen assets for court-reviewed approval until final probate resolution. In practical terms, they no longer had unilateral control over the structure they believed they governed. Payroll continuity was the first priority addressed. Employees across essential divisions were notified that compensation systems would resume under verified authorization channels tied to the continuity structure. Vendor contracts were reinstated selectively, prioritizing operational stability over expansion plans. Investors, who had initially pushed for aggressive restructuring during the freeze, were now informed that all financial projections would be recalculated based on corrected ownership clarity. The reaction was not emotional, it was administrative recalibration. Meanwhile, Emily Carter did not suddenly become the public face of the company or step into a visible leadership role. Instead, her legal position was recognized in precise terms. Designated continuity operator with authority over defined financial and operational systems under the CEO's estate structure. That distinction mattered. It was not symbolic power. It was functional responsibility. Walter Gaines made that clear when speaking to court compliance officers, emphasizing that this was not a takeover, it was restoration of intended structure. Outside the courtroom, internal corporate communications began updating authorization charts. Certain executive approvals were suspended pending verification. Others were rerouted through legally validated channels tied to the continuity file. Board members who had previously dismissed Emily were now required to acknowledge her role in operational stability reports submitted to the court. No confrontation was necessary. The documentation itself enforced the correction. And in that quiet enforcement lies the real lesson that emerged through the case: financial systems do not collapse because of disagreement, they collapse when people confuse assumption with authority. A simple checklist, repeated internally by compliance officers reviewing the case, captured the core principles that had been ignored for too long: keep records consistent, read contracts fully, know whose name is on the title, track cash flow instead of reputation, protect signatures as legal instruments, never confuse approval with ownership, and never allow emotional pressure to replace documented proof. Each of these principles had been violated at some stage in the board's original assumption of control, which is why the system had frozen in the first place. Now, each of them was being restored in reverse order through legal enforcement rather than debate. Emily's role in this phase remained understated but structurally central. She reviewed corrected filings, verified authorization pathways, and ensured that restored financial flows matched legal boundaries defined by the court. There was no celebration, no reversal of fortune, no dramatic shift into dominance. Instead, there was alignment, slow, procedural, irreversible. Walter observed quietly throughout, understanding that most people would misread this outcome as a story of victory or loss. But in reality, it was neither. It was a correction of who had been silently maintaining the system all along without recognition. And as the legal framework stabilized, one unresolved question remained at the center of everything. Now that the structure of authority had been revealed and partially restored, what identity would Emily Carter ultimately occupy in a system that had been operating under her signature far longer than anyone had been willing to admit? By the time the court session reached its final administrative closure, nothing about Halston Enterprises looked like the frozen empire it had been just days earlier. What remained was not collapse, but recalibration, quiet, procedural, and irreversible. The sealed authorization file had already been entered into the official probate record, and every downstream system in the company had begun adjusting itself to match what the law now recognized as reality. Payroll systems resumed under restricted continuity protocols. Vendor contracts were reactivated in phases. Bank accounts tied to essential operations were released under court-supervised authorization channels. No headlines declared victory. No one in the room celebrated. Because what had changed was not emotion, it was structure. Emily Carter stood once again in a quiet corner of the courthouse hallway after the final hearing, holding a thin folder that now carried far more weight than its appearance suggested. Nothing about her outward presence had changed. No new title was announced publicly. No dramatic promotion followed. But internally, within the legal framework of Halston Enterprises and its estate structure, her role had been formally recognized in writing, designated continuity operator with verified signature authority over defined financial and operational systems. It was not power in the way people imagine it. It was responsibility embedded in documentation. Walter Gaines stood beside her, calm as always, not as someone who had helped her win, but as someone who understood exactly what had just happened in legal terms. He had seen it before in other estates, other companies, other disputes where people confused visibility with control. He knew that the system had not rewarded Emily, it had simply confirmed what had already been true in practice. The quiet white billionaire mentor did not speak in dramatic conclusions. He spoke in patterns. And the pattern here was simple: money systems do not bend to personality, they bend to structure. Across all of it, the same truth repeated itself in different forms. Ownership was never about who spoke the loudest in a boardroom. It was about whose name survived in deeds, contracts, and trust structures when everything else was stripped away. Cash flow did not respond to reputation, it responded to authorization. Signatures were not symbolic, they were enforcement points that determined who could move resources when pressure arrived. And records were not passive, they were the final authority when human disagreement reached its limit. Emily had learned this not through theory, but through proximity. She had spent years inside the quiet machinery of Halston Enterprises, watching how decisions were actually executed beneath the surface of public leadership. While others focused on titles, she focused on documentation trails. While others built presence, she built understanding. While others relied on trust, she relied on verification. And when the system was tested by loss, confusion, and competing claims of authority, it was not visibility that held it together, it was structure she had already been maintaining without recognition. Walter had once told her that people who truly understand money do not try to perform power. They build systems that do not require performance at all. Systems that survive absence. Systems that survive pressure. Systems that survive misunderstanding. That lesson now sat quietly behind everything that had just happened in court. The younger white woman who had once been dismissed as irrelevant, too quiet, too simple in appearance, too far removed from executive identity, was now legally recognized not through emotion or argument, but through documented continuity authority embedded in the estate itself. And yet there was no sense of personal transformation into something louder or more public. Instead, there was something more important: stability. Not the kind that depends on perception, but the kind that exists because the paperwork has already been tested under pressure and confirmed by law. Walter adjusted his coat slightly before speaking one final time, not as a mentor delivering advice, but as someone summarizing reality. Most people think power is something you show, he said quietly. But in systems like this, power is something that remains after everything else is questioned. Emily nodded slightly, not because she needed reassurance, but because she understood the structure now at a level that no longer required explanation. The courtroom, the boardroom, the legal filings, the bank records, they were all just different expressions of the same principle. Truth in financial systems is not declared. It is proven through documents that survive pressure. As they stepped toward the courthouse exit, the noise of the city returned around them, indifferent and constant. Nothing about the world outside had changed. But inside the structure of Halston Enterprises, everything had been quietly redefined. And in that contrast between external normalcy and internal correction, the final lesson of the entire case settled into something simple, permanent, and difficult to forget. Do not spend your life trying to look powerful. Build a life where the truth, the records, and the assets can protect you when the room turns against you.